Number 94, Molinaro versus Warden. Counsel?
Good afternoon. Julian Joris for the People, appellant. I'd like to reserve 2 minutes rebuttal, please.
You have 2 minutes.
The appellate division's decision in this case leaves trial courts effectively powerless to enforce orders for competency hearings. Now, in any case where the defendant is charged only with non-qualifying offenses,
But aren't there provisions in the mental hygiene law that if someone needs an examination, they could be invoked for that purpose?
so the provisions of the mental hygiene law, I believe Your Honor is referring to 9.43 and that area, that is really a specific, really public safety-oriented provision or collection of provisions that have to do with defendants who may be a danger to themselves or others. It is, 943 is essentially a court-ordered ride to an emergency room to determine.
So why should someone be held for bail in a non-bailable offense simply for the purpose of an exam? And where in the CPL does it provide that you can do that?
So first, the purpose of holding someone under Article 730 is simply if the court believes that is necessary in order to ensure that the defendant will actually show up for the 730 exam.
Actually, it's usually to see if they're competent to participate in the proceedings.
Right, that's the purpose of the exam, and the purpose of holding the defendant for the exam is to make sure the defendant will actually show up. You can't.
Where's the authority to hold them without bail so that they can simply be examined?
That stems from Article 730, specifically 730.20 sub 2. That is dealing with defendants who are not otherwise in custody. And it's clear there, although I'll say it's unambiguous there. The statute could be phrased more clearly, but it's unambiguous. The phrasing is the court, if the defendant is at liberty, the court may order an outpatient examination. The necessary implication there is, or the court may not.
That's the clarity? The clarity comes through the necessary implication?
That's correct, Your Honor.
I mean, there are no words in that section that say the court may order outpatient or secure to a facility, correct?
That's correct. We are arguing, and we have argued all along, this is simply what is necessarily implied from the text of the statute.
So you're adding, I'm sorry.
I was just going to say, just continuing on with the text of the statute, it does provide an explicit alternative in the statute, which is that the director of a facility can request placement into a facility. It seems as if the may might relate to either of those two options and not some necessary implication whose words are nowhere to be found in the statute itself.
So I think if we were to look at subdivision 2 in a vacuum, I think that argument might have some traction, but then you see immediately below at subdivision 3, we have a parallel construction. The court must order the examination to take place where the defendant is being held in custody. And then, even though that is a mandatory must, immediately following in subdivision 3, we have this exception, this carve-out, if the director feels it's necessary, then instead of being, where the defendant is held in custody and jail, then it's conducted in a hospital. So the may in subdivision 2 isn't just to allow for the possibility of hospital confinement. If that were the case, it would have been written with a must, the same way as it is in subdivision 3.
So the may provision takes you to, for the not in custody subject, somehow takes you down to the next section for the in-custody subject?
No, Your Honor, what I'm saying is that we can tell that where it says may order it on an outpatient basis, that isn't just to allow for an exception for hospital confinement, because when we contrast that with subdivision 3, there it says must occur where the defendant's being held in custody, and yet, despite that mandatory language, has a carve-out.
However, there's a distinct difference. Subdivision 2, 730 subdivision 2 simply describes arguably what the court's options are if the defendant is not in custody. Not that you can hold them.
So it provides it says you can have, again, this is permissive, not mandatory language, you can have an outpatient examination when the defendant otherwise would be at liberty.
And that makes sense because they're not in custody. However, if they are in custody, it would make sense that different language is used because they are in custody, so that you have to do the exam in a certain prescribed manner because they are held in a facility.
Are you referring to subdivision 3?
Yes.
And so what we
So
see...
there's a reason for the difference.
There is a reason for the difference. The reason for the difference is under subdivision 3, the defendant is being held in custody. The only question is where, right? Under
Correct.
subdivision 3, it's jail or hospital. And under subdivision 2, and this is really one of the main differences from the predecessor statute, the Code of Criminal Procedure, subdivision 2 adds another possibility, says, or the defendant can stay at liberty. You could have an outpatient examination.
Well, it would have made sense then to have 3 come before 2, but I want to ask you a different question. So 2 says, when the defendant is not in custody at the time, a court issues an order of examination because he was theretofore released on bail on his own recognizance. Now, I didn't understand that to be the case here. So number 2 only applies once you've already been released. Here there was a presumption of release, but that order had not been signed. So I don't understand how number 2 applies at all. That's my challenge. I'm having difficulty seeing how 2 applies at all.
So, Your Honor, if we're under 3, then the defendant has to remain in custody. Then we're under 3.
No, that's my
Yeah.
point. I understand, because I thought you were saying the authority stems from 2. If I've misunderstood you, that's a different situation. But I thought you were saying the authority for the judge to do what the judge did here flows from number 2. But I'm not sure 2 applies, is my point.
So I think if we're under sub 3, then
Yes.
I think I don't believe any dispute that the defendant remains in custody unless the director says a hospital confinement is
Well,
necessary.
yeah, that's my point, because
Right.
2 is qualifying the nature of the custody, 3 is not, just as custody, right? So I guess then going further on this issue about number 2, can indeed the court order an examination before making a determination on bail? That then I think is the next question to try and answer my question about number 2.
Right, I mean, that has, I would say really it's just a matter of really the timing. I don't know that
Well,
the
yeah, is
order-
there any prohibition on issuing the order before you've made a determination about bail? I guess that's the way to put that.
I don't see any prohibition in the text of the statute.
Okay.
That, of course, depends on, and there was some argument about this in the appellate division, what the definition is of after arraignment. Does it mean after the entire arraignment proceeding, or does it mean after the defendant has been brought up to the arraignment court?
The
I
entire
would-
process of arraignment, as opposed to the end of arraignment.
Correct, Your Honor.
Can
Now-
I ask you a question, a
Yes.
practical question about a part of sub 2? How hard is it for you to get a director of a hospital to say, we need to do this, we need to confine the person in the hospital?
To be perfectly frank, I have never heard of it happening, certainly in Kings County, I believe in New York City.
Is that for want of trying, or why?
I-
Or it's because it's tried and it's rejected?
Quite frankly, my understanding is we have been attempting for a year to figure out who the director is for this statutory purpose. This is not like a person who's in charge of a hospital that can take patients. There's a 7:30 clinic, I believe. I forget what city agency exactly it's run out of. But, more broadly speaking, certainly, right, the mechanism of asking the director to opine on this, I think, is just, even under the best of circumstances, impracticable. Certainly, the director can't be there in every court part, or even if we're just talking arraignments, day shifts, night shifts,
Well,
7 days a week.
Presumably that could be delegated to somebody or some group of people by the director, no? But your point is you don't even know who the director of one of these hospitals is.
I've never heard of the director provisions being used ever. Again, I think in New York City in general, and certainly not in Kings County.
But if the director, whoever they might designate, is not available, is it your position that the court can merely hold the person until that person's available? To come and make this determination under paragraph 2?
I think that's an open question under the appellate division's decision. I would argue there would be at least some, if we're relying on the director's availability or some designee's ability to opine on this, I would say, well, the court should be able to hold someone at least until the director can make that decision. That being said, the appellate division didn't have occasion to address that, obviously, and so far as I know, it has not, practically speaking, come up. I'm sure
Counsel,
eventually
can I
it
ask
may.
you something before your time is up? But the harm you're seeking to avoid is the person doesn't show up for the exam, right? They're going to be out on bail, or not bail, they're going to be released, they're going to have to show up for court. So let's say they don't show up for the exam. You have no recourse as the prosecutor.
So effectively, no. I mean, if we're speaking especially with someone who's a non-qualifying offense, bail can't be set, let alone remand. If this person is showing up for court, and again, the mental hygiene law provisions, 943 and so on, don't apply, that there are provisions in the bail laws for someone who willfully and persistently fails to appear for court. That's a separate issue. These may overlap, these may not, but for the purpose specifically of ensuring someone shows up, ensuring the examination can happen, so that we can tell, is this someone who is incapacitated, or is there going to be a trial? No, there's no feasible alternative here.
Would they be in contempt for obstructing the proceedings?
I don't know that that's ever been tried, Your Honor. But
Thank you, counsel.
thank you.
Good afternoon, Alexandra Ferlisi for Sarah Molinaro and Petitioner Whaley.
Do you agree with that? There's no recourse for the prosecutor if the person doesn't show up, defendant doesn't show up for the exam?
No, absolutely not. There is recourse within the bail statutes. So generally, in a practical matter, when competency exams are issued in Brooklyn, they are set the same day as the court appearance. So missing one pretty much necessitates missing the other. In those situations, the court can, and ideally would, use the bail statutes, specifically 530-60, to revisit bail as it is set, reconnaissance as it is set, to see what the person needs in order to come back to court. Of course, reconnaissance alone is not the only thing available to the court when it's a non-qualifying offense. Non-monetary securing orders, including supervised release, are normally and used in force to get people to return to court and get them resources they need within their community.
Do you have any sense practically if defendants are undergoing these exams on an outpatient basis?
My understanding is that they are very common in outpatient proceedings, and that the hospital director's input to confine them is just not typically necessary. I haven't had personal experience where there is a problem where the director would need to get involved in that respect. So my understanding is, yes, they are commonly going forward in the outpatient settings.
Could you tell me why paragraph 2 applies?
Paragraph 2 applies because the courts must arraign the defendant before a 7:30 exam could be ordered. So anytime a person comes before the court, a
And the
securing,
source of that is where?
in the bail laws, Articles 510, 530, all say that a securing order must be issued at arraignment within that title, Title P of the Criminal Procedure
Why
Law.
can't it be done simultaneously?
Simply because, first of all, the bail laws say that, first of all, the person must be arraigned. Second of all, in 730, the articles and the text of the statute presupposes, as the appellate division had said, that a securing order had been issued, primarily based on the theretofore language in 730.20 and 730.20 subsections 2 and 3, where the court, the appellate division found that that language itself, again, presupposes that the bail laws had been followed, which
I
was
don't
not
really
here.
understand why, I'm having difficulty understanding why that language is there, because your point is true without that language. They're not in custody. They're just not in custody.
Correct.
Period.
They're technically in custody in terms of, being in the courthouse in the back, being held for arraignment. So in that respect, they are technically in custody until the arraignment, in which case a securing order must be set. And our position
But
has
during the arraignment, they're in custody. You agree to that, right?
agreed until the securing order is set, yes. And that securing order must be done, we
Either the
believe, first.
custody's continued,
Custody could be continued.
or they're released, right?
Exactly. And, when the release is required, then this subsection 2 kicks in force.
Yeah, but again, I understand that, but that would be true without this section, and it does say, because he was theretofore released, not because he's entitled to be released.
Well, yes, of course, this was written before the bail amendments required
Yeah,
release under these
right.
circumstances, particularly for Mr. Lee. But this was a real move by the legislature to get it out of this mandatory 60-day hospital stay. So these outpatient procedures for people who are either on bail or out on bail or required, mandated to be released, has to be directed somehow. The courts have to be empowered to do this outpatient, which they weren't before 1970. Of course, the legislature and the courts do need to be empowered to direct hospital confinement, which is again why that may is in that first subsection there. So, yes, while,
So why doesn't it say must?
it doesn't say must because there are two options in this subsection, whereas there's one option in the subsection 3. It doesn't need to say must here. It can be very easily construed as a mandatory provision, which has been on multiple occasions.
Well, you'd say must be done in an outpatient provision unless,
Of course, that, would be.
and then they may or must, whatever the legislature decides.
I think that would be better, and there, if this was a case
But
of
if
better.
3 has must, why does 2 have may, and why does it have this language which is superfluous about theretofore released?
I don't believe it's.
You might not have written it this way, I understand that.
Yeah.
But this is what we have, and of course in LaBelle, we've already recognized that there's some ambiguity in the statute, and there's a
Well,
problem.
I believe in LaBelle, that was more of an issue of the court saying that it was simple legal error, whereas not necessarily judicial misconduct.
Right.
But this section, if this was an
But
issue.
that went to whether or not the judge could be viewed as having acted in violation of rules of proper judicial conduct, because it was not so obvious that what he was charged, or some of the things he was charged with doing, he couldn't do. That's the point of that ambiguity language, no?
I think in
LaBelle. That's that reference, I think.
I think it's just that it's so specific to judicial misconduct and not, the court, even in LaBelle, did not look upon this favorably. It was more of a legal error issue, and I believe the court even said something to the effect of, we believe our interpretation that the judge was wrong is the correct interpretation. But it was just not the level of judicial misconduct.
Well, to get back to Judge Rivera's original question, there's a way to construct this statute, and I don't know, maybe it's just a drafting disagreement you have with the legislature, but you could have drafted Section 2 with a must I think she suggested must unless construction, which would have been much more clear. But is that the explanation for why May is here? That it's just bad drafting? Or is it possible that it actually means something slightly different than what you're arguing? Right?
I wouldn't even say it's bad drafting. I think this is, less than perfect drafting. I think that it could have been a must
stand
without
corrected.
it being, I just think that there is, the level of inference necessary to make this may mean that remand can be instituted without express authority is an extreme step, where may is very easily interpreted as a mandatory provision, which again, it has been multiple times in the CPL.
But lower courts have said that trial courts do have the power to remand for these exams. And the legislature, we presume, is aware of that interpretation and yet has continued with this same language.
Two
How
lower
how can you
courts-
explain that?
Two lower courts prior to the bail laws being changed did say that. Those issues were not addressed by a higher court, and as soon as a higher court, the Appellate Division Second Department, was able to address these issues, it came out in the negative. They cannot be doing that. Knight Ritter and all of those other cases that, would say that the legislature is imputed to know this, I don't think apply here because of the lower nature of the decisions, and the fact that, even if we're going to say that the legislature was aware of this, they did make a provision within the bail laws to eliminate the prior decision's application. In the bail laws, it says that, the court must set a securing order in accordance with this title, meaning Title P of the Criminal Procedure Law. 730 is not in Title P, it's in Title U. So that one phrase essentially abrogated any holding that this could go forward. Now, the two cases that were decided after the change of the bail laws are simply incorrect. And again, as soon as the Appellate Division could review those issues, they have found in the defendant's favor.
But the legislature could have reviewed that when they were redrafting, and they didn't. Should we ascribe any meaning to that?
Well,
What about the treatises, and isn't there a judge's handbook? I mean, it's not just a couple or a handful of lower court decisions, right?
There's a couple, I believe that most of those other secondary treatises
Sources.
do rely on those cases. So those cases did infect a lot of that jurisprudence. So I think we really have to look at the legislative intent here, and that has been clear and consistent the entire time. The legislative intent is very simple. The status of an accused who has been enlarged on bail should not be changed because of a pretrial examination. The Code of Criminal Procedure was much more restrictive, and they went to a more permissive outpatient setting.
I guess the question is, if that status hasn't yet been determined and an order issued, can you do this? That, again, that's my problem with paragraph 2.
I
I
it's
think there's
less-
ambiguity, I think there's a gap, I'm not sure it gets filled the way you argue it gets filled, that's my problem.
I believe it gets filled by the plain, easy way of actually doing the bail securing order correctly. And I think that has to happen first, and I think there, again, then a 730 exam can be issued. That just wasn't followed here, and there are
Let me
practical...
ask you a different question. Is there anything in the record, given the colloquy, where the judge makes some statement or some finding that the judge is concerned that the individual would not return or would otherwise not be cooperative with the exam? Which strikes me as that's why you're holding them, because they're going to come back while you're holding them.
My memory of this case is that the court just saw some erratic behavior and said summarily remanded for the 730, as was common practice in many cases, really. And, arraignment must go forward under
Well, it's common practice, then you'd really think the legislature would act.
I'm sorry?
If it's common practice, you'd really think the legislature would act.
Well-
Not wait for all these people to be held while a case finally makes it to us.
Again, I think the legislature did act, but really, this legal error cannot be grandfathered in, particularly when we have these 4 lowercase decisions that the people are, clinging to in this aspect, again, which were unreviewed by a higher court until this case.
Thank you, counsel.
Thank you.
So I'd like to briefly note, I think, two things my opponent said, which actually, if I'm interpreting correctly, I agree with. The first is that this is all about the legislative intent. We agree there. And the second, I believe there was an acknowledgement that you could change the first may under sub 2 to a must, and that would yield the interpretation that the defendant is arguing for. And where I think we part ways is I think here, especially when you have two subdivisions, one after the other, one uses the permissive may, one uses the mandatory must, we can't just assume, well, because sometimes they use the may in a mandatory sense, here, though they're using different words, they must have meant the same thing.
Does the may open up any other possibilities other than the one that the judge here chose, which was to remand this person to jail? Could they, I don't know, direct them to be locked in a closet somewhere until the exam could be held, or shipped off to a large waiting room? I mean, what's the limitation? If the words may, and that gives the judge this sort of unfettered discretion, what's off limits in your version of this?
So I wouldn't qualify it as unfettered discretion. I will say as a practical matter, what courts have done when the defendant is not otherwise, being held on bail or remand, is either order an in 730 or keep the defendant at liberty. So those are the two options that I think we've really seen at play. But I think really that's not necessarily the only option, and I think, though it is, the only one that's at issue here, because that's what the judge did, I mean, I think this is really something where that's what habeas review is for. In an individual case, if a judge says, well, I'm doing, I don't know, a supervised release to make sure you show up for the 730, even though I wouldn't order it under the bail statute, something like that. In an individual case, the particular terms could be reviewed on habeas review. So I don't know that I have an answer for, what's the hard and fast rule. I don't know that there is a hard and fast rule, but I do believe the statute very clearly allows for what the judge did in this case, which...
So on the legislative intent, if I understand the defendant's position about what the legislative intent shows, is that the Bartlett Commission recommended and the legislature acted to ensure that if somebody was entitled to release on bail, that person wouldn't be held simply because of the need for a 730 unless the director of a hospital said so. Do you have a different understanding of the legislative history?
I have I think, subtly different understanding. The way I read the legislative history, especially in the context of, again, the Code of Criminal Procedure, which just assumed someone would be in custody, is the defendant wouldn't be held solely because a 730 exam was ordered, right? And we're not saying solely because. We're not saying, well, you ordered a 730, therefore the defendant has to be in custody. We're saying it should be an option if the court is sufficiently convinced that the defendant would not show up for the exam. It should be a possible option that the judge can order the defendant held in jail to show up. So I think that's...
But then that goes to the question that you were asked earlier about what in the record, if anything, says that the judge here made that determination.
Yeah, I do agree it's not the most robust record in terms of the arraignment court, but that is, and this is, again, what has been in the really uniform interpretation in the trial courts until the appellate division's decision. It's this understanding that the ability to order an in 730, and she says, I believe, I'm ordering him held for the 730, words along those lines. So making it clear it's for the purpose of...
Well, of course, I mean, the purpose, that's the whole point of 730, purpose of the exam. The question is whether or not you can just hold someone because you want them to have the exam, or whether or not you need a finding, and something in the record supports the finding, that the judge thinks that you might not show up, and so that's why they're holding you.
And
Or that you might be a danger. I mean, I get, there are other articles that might address some of that.
And I believe it is,
Otherwise, aren't we back to what she was describing before as the bad old days? Everybody goes in, everybody stays in till the exam is done?
so I believe it is clear enough from the record here that, again, the judge says something to the effect of, I'm holding him in for the 7:30, that this is, right, it's after seeing the defendant's erratic behavior, I would say, is an
Well, that's
understatement.
suggesting the competency, right? That's not necessarily a basis to say that they're not going to be cooperative with the exam.
Well, it can be both, right? The same sort of behavior can give you concerns for both. And here where the defendant didn't believe the judge was a judge, didn't believe his attorney was an attorney, didn't want the interpreter to speak, that kind of behavior would not only give you concerns about competency.
Okay, your red light is on. Let me
Yes.
just ask you, can you just quickly address your adversary's point about the securing order issuing on the Title P?
Oh, yes. This, I believe, is a defense argument that the 2019 amendments to the CPL effectively abrogated this interpretation of 730. No, absolutely not. You see, and this is addressed in our brief, you see when the amendments to the CPL wanted to change other provisions that were affected by these changes in the bail statutes, they changed those other provisions. They didn't just obliquely say, oh, leave some language in the bail provisions that you could maybe interpret as affecting other statutes. When they wanted to change the other provisions, they did. And in fact, they inserted the words in this title or pursuant to this title in several places where there was no dispute that it was talking about bail. So, and it's, again, I see my red light is on. That's, I believe, fully addressed in my brief.
Thank you, counsel.
Thank you.